distinct pleasure and honor to introduce to you one more time Dr. Kenneth Mott, and his students call him the man.
Some of them. The real reason we're here is not to talk about the Bill of Rights. It is to help Betsy as she goes about the process of collecting chickens. If you have some extra chickens around, bring them over to
Send them
Betsy.
my way.
2,000 more.
Her target is 80,000. 80,000 is the target,
Yeah.
according to the
Right.
Gettysburg Times. All right.
It is 80,000.
Okay. Wasn't at all sure about how to approach this tonight. It's a lot of difficulty, I think, in trying to talk about the entire Bill of Rights piece by piece. And so I thought I would take a different tack tonight. But suffice it to say, here's the Bill of Rights in a nutshell. You've all memorized it, so I'm not telling you anything, right? Amendment 1 deals with very specific rights: freedom of speech and press and assembly and religion, so on, all right? Very specific things. Amendment 2, the right to bear arms, which is somehow connected to having a militia. And of course, in the old days when that was written, we were all members of the militia, right? All of us who could fight, okay? Potentially. 3 says we have a form of privacy in that we can avoid having members of the military in our house or on our property, except in times of war, all right? So if you open your bedroom window some nice spring morning and you see bivouacked out on your lawn the 17th Battalion, you can just say, "Get the hell off my lawn." And you're within your constitutional rights to do that. Okay? 4 through 8 talk about the criminal justice system. Right? The guarantee against unreasonable searches and seizures, the right not to have to testify against yourself, the right to counsel, and so on and so on. The 8th Amendment speaks about cruel and unusual punishment. 9 and 10, I think, are really interesting because those don't nail down anything. They talk in very vague terms, but they're very important symbolic terms. Remember, 9 talks about rights in a general sense, and it very specifically says there are other rights. Not the ones listed in 1 through 8, there are other rights which are retained by the people. That's really important. It's really telling us 2 things. 1, this is not an exhaustive list of rights. There are indeed others which are not listed. But it also tells us, I think, this goes way back to the Declaration of Independence, that our rights come to us from God. Literally. That's what we mean by inalienable rights, right? To borrow Tom Jefferson's language from the Declaration of Independence. They come from God. They do not come from the state. And that's why there are other rights retained by people, okay? And of course, 10 then speaks not to rights, but to powers. And it very specifically limits the powers, reminds us of the limits of powers of the federal government, right? Those powers which are not specifically delegated to the government are retained by the states or the people, okay? So these are very important general reminders. Okay. When you step back and look at the Bill of Rights, I think I at least am struck by 2 things. One is that in some areas it is very specific, very specific. Congress shall make no law prohibiting the freedom of speech, the press, and so on. That's pretty specific stuff. Then there are other parts of the same Bill of Rights that are very general. Guarantee against cruel and unusual punishment. Well, what on earth is that, right? We could probably all agree that it precludes boiling in oil. But does it preclude the death penalty? Does it preclude extended sentences for having a little crack cocaine on your person? Well, we fall to fighting about that. In a very real sense, folks, when we talk about the Bill of Rights, we have to talk about the Supreme Court. Charles Evans Hughes. You know what I'm talking about? Charles Evans Hughes. He was a candidate for President of the United States, right, on the Republican side. He was a Secretary of State. He was the governor of New York State. And eventually, in the 1930s and early 40s, the Chief Justice of the Supreme Court. But the interesting thing is, back in 1907, when he was hardly any of those things, he made an interesting observation. It was very simple. He said, the Constitution is what the court says it is. That's it. Right? So you can read the words all day long, but until the court gets into it and starts defining and giving meaning to those words, we really don't know. We really don't know. Okay? Now, rather than talking about specific items, and we can get to those later on, if you'd like to do that, you can. I'd rather talk about several general approaches that the Supreme Court has taken over the years to give both breadth and depth to the Bill of Rights. And let me start by talking about breadth. In other words, getting to the question of to whom do the Bill of Rights apply? All right, good question. Well, originally, the Bill of Rights applied only against the federal government. Okay. Ratified in 1791. These are rights that we hold against the national government. Remember, the government is always the bad guy when it comes to the Bill of Rights. Okay? It's the government that we have to look out for, not our neighbors, the government. Okay? All right. So, here's what happens. Here we have something called the Bill of Rights. All right, here are the provisions. And on one side, we have the government. You all recognize that. On the other side, so the Bill of Rights creates a barrier between the government and us. All right? Fine. But now you have another government down here. Let's call it Pennsylvania. All right? So the national government is prohibited from restricting our freedom of speech, Amendment number 1. But that says nothing about the Commonwealth of Pennsylvania restricting our freedom of speech. So, in effect, Pennsylvania can do a little end run here and limit our freedom of speech. There go our rights. Okay. So, how do you extend the barrier down here so as to preclude that from happening? How do you extend the Bill of Rights provisions to the states? And the answer is incorporation. And this is where the court starts to play games. This is where the court gets creative. Right? And it starts roughly in 1925 with Gidlow versus New York. Gidlow is a case that involved both freedom of speech and freedom of the press. And it was New York that convicted Ben Gitlow. He was a rabble-rouser. He was a socialist. He was standing out there on street corners, handing out pamphlets, overthrow the government and so forth. And he was arrested, and he was convicted under a law of the state of New York. Right? Not a national law, but a New York state law. And he appealed his conviction to the Supreme Court, and he said, I think I have been denied my rights of freedom of speech and press. Okay, well, the court, being creative, said, you know what? We agree. We agree that the guarantees of freedom of speech and press, as they're lined out in the First Amendment of the Bill of Rights, ought to apply against the state of New York as well as against the national government. How do we do that? Well, down here is Amendment 14. Amendment 14 says, no state shall deny to any citizen the right of life, liberty, and property. 1868. So the court focuses on that language and says, you know what? The Due Process Clause of the